and welcome everyone to our webinar today. Please be aware that it will be recorded. Are there any objections? No, excellent. Then we'll get started now. Welcome to today's webinar. We are New York State Office for New Americans based in the Center, Utica, New York, and I'm Alicia Baranova, the project coordinator of the program. Today, we are holding a webinar in collaboration with the Center's Traffic Safety Program, HISCAC Legal Aid Society, Oneida County Court Judge, and Oneida District Attorney's Office. In today's webinar agenda, we will discuss the impacts of driving without a license and DWI. The Zoom session provides 40 to 45 minutes of information with the time left at the end for the questions. And just a reminder before we get started, please feel free to ask questions at any point during the presentation or put them in the chat box, and we will address them at the end of the presentation. And with that, we will open today's webinar. I have the pleasure of introducing Karen Southwick, the immigration attorney at the HISCAC Legal Aid Society and ONA Legal Counsel. Welcome, Karen. And now I'd like to pass it on to Lizanne Devine, our Traffic and Safety Program Manager, who will introduce our other guests. Lizanne, please.
Hi, so I am honored to have Honorable Judge Greg Amoroso, who is the Rome City Court Judge and acting Oneida County Court Judge, and Rebecca Kelleher, an Assistant District Attorney for the Oneida County District Attorney's Office, who specifically handles vehicular crime prosecutions. Our goal for this conversation are to increase awareness of DWI and driving without a license, and ultimately decrease the number of these driving crimes. Thank you for coming, and we look forward to having a great discussion today. Judge.
Okay, hi, I'm Judge Greg Amoroso out of Rome City Court. I'm also an acting Oneida County Court Judge. For a period of time, I did handle all the felony DWIs in the county. I'm not doing that at this time, but have quite a bit of experience in that area. And we're going to really present some basic information and give you some input on what the consequences can be if you are driving without being properly licensed, and or if you are driving while under the influence of drugs and alcohol. So I will probably speak on each slide and then turn it over to the two attorneys and Lisanne for anything they want to add or ask. So let me go ahead to the first slide, Lisanne. All right, so the first slide deals with a traffic infraction driving without a license. What's the difference between a traffic infraction and a crime? That is that a traffic infraction is when you're violating a rule, and they usually have to do with rules of the road, but it doesn't have criminal consequences. So it won't show up on your criminal record. It's not considered a crime. Probably the most common traffic infractions we all know of are speeding violations, not obeying a stoplight or a stop sign. You still have to go to court, but you're not charged with a crime. So one of those that we're going to discuss specifically today is driving without a license. And what this means is either you were never granted a license or your license is suspended, but you didn't know about that. If you look at the second bullet on the slide, it says no knowledge requirement. That means that the prosecutor, the district attorney's office, will not have to prove to the judge or that you knew your license was suspended. It will just have to prove that it was suspended or you never had one. Because it's not a crime and there's no criminal consequences and it's not likely to result in any jail time, you do not have the right to a free lawyer. So when you come to court for the traffic ticket, they'll give you a date to come to court. If you want to have a lawyer represent you, you need to find them on your own and hire them before you go that day. Or you can always represent yourself on a traffic matter, but the court will not appoint a lawyer to represent you. And we'll talk about later cases which that will happen. And normally, if you are convicted of driving without a license, usually the consequence will be you got to pay some money. There'll be a fine and some surcharges, which is a little different than a fine. So that's the basics of that. So I think maybe it would make sense to turn it over to Rebecca first, each slide, and then over to Karen to see if there's anything they want to add. And then finally, Lisanne for anything any of us said that needs clarifying. So Rebecca, anything you want to add here?
Just add briefly, Your Honor, that traffic infractions, even though they aren't crimes, they are still prosecuted by my office. We recently created a traffic resolution unit, which handles requests for plea dispositions through the mail. So that's something that people who are charged with traffic infractions can avail themselves of.
Thanks, Rebecca. Karen, anything on the traffic infraction of driving without a license?
Sure. Thank you, Judge. Very generally, traffic infractions, things like speeding tickets, will not probably have any sort of immigration consequence. I will say that if you are someone who is here without permission, if you are undocumented, if you are stopped in a traffic stop, it could have very dire consequences. Anytime you are questioned by the police, or your identity is questioned, it's a very big risk that you would be taken into custody and placed in deportation proceedings. But if you are driving without a license, that alone, it is, as the judge said, a traffic infraction. If you have your green card and you want to apply for citizenship, this offense alone probably would not hold you up in terms of getting citizenship if you didn't have any sort of other red flags. But it is an offense. And when you apply for citizenship, you do have to answer questions about any time you have been arrested, if you have ever been cited or committed some sort of offense that you maybe were not prosecuted for. But even if you've committed an offense, you do have to answer yes on your application. So you potentially would have to include more information about this in your application. But that's not to say that it would stop you from getting citizenship. So, this might be a little bump in the road, but it's probably not a roadblock to someone who has permission to be here and is applying for citizenship.
Thanks, Karen. Lisanne, anything that you think need clarifications on this one? You're nodding your head no, you're muted. So I'm assuming you want to just move on?
No, I'm good. We can move on.
Okay, yeah, this was the simple beginning. So, all right, so now we're going to get a little more complicated, and this is a crime known as aggravated unlicensed operation, which is a very long, fancy title. Most of the time in the criminal justice system, you'll hear this referred to as AUO. So if anyone mentions AUO to you, that's what they're talking about. And the reason that that's important is because you will get, when you're charged with an AUO, if you're stopped on a traffic stop, you're going to get a ticket just like you would get for a traffic infraction. So you might not realize that this is a little bit more serious. So if you see the words aggravated unlicensed operation or AUO, you are being charged with a crime. And it can be a misdemeanor or even a felony. And the difference between misdemeanor and felony is the level of punishment you can get. For misdemeanor, the most you can do is 1 year in Oneida County Jail. With a felony, you can do, you would go to state prison and you can do significantly more time than a year. So the difference between AUO and unlicensed drivers that we talked about in the last slide is that in AUO, there has to be proof that you knew your license was either suspended or revoked. I'm not going to get into the difference between suspension or revoked because there's it would be a lot too much detail for us to talk about today. But some reason the court DMV has said you've done something that your license is no longer valid. Either you didn't show up in court, you didn't pay a fine, you'd had a DWI, whatever reason you didn't pay your child support, they've suspended your license. Now, when I said that the DA has to prove, that the district attorney has to prove you knew, that doesn't mean that they have to do that by you saying you knew. Really, they can do that very simply by showing that the Department of Motor Vehicles sent a letter to the address you gave them saying that your license was suspended or revoked. As long as they can show that was sent, they've met that knowledge requirement. Now, on an AUO, I guess I said will be entitled to a free lawyer. That might be too broad. You have to financially qualify, but most people who come to court are below the income levels where they can qualify for a free lawyer. So unless you have a really good job where you're making a lot of money, for the most part, you can come to court and a lawyer will be assigned to you and they will be in the courthouse already that day. You don't have to use that free lawyer. You can choose to hire your own if you want to, but that's an option to use that court-appointed lawyer. If you are convicted of AUO, there's going to be usually the punishment can be money fines. On the next slide, we'll talk about the fact that there can be higher punishments too, including jail and probation. But it's a crime rather than an infraction. So the amount of money is going to be higher. You're going to be paying more money, anywhere from $300 to close to $1,000 just for violating this law and committing this crime. So it's much more serious than the unlicensed driving. Rebecca.
I don't think I really have anything to add to that, Judge Amoroso.
Thanks. Karen.
Sure. So I would recognize that this is a little bit more of a step up from a traffic violation. It is a crime, so therefore there certainly could be more consequences. Again, if you're someone who is here without documentation, if you are arrested for this, you're very likely going to be detained. If it becomes apparent that you don't have permission to be here, and you may be sent to immigration court. If you are a refugee or have some other permission to be here, such as TPS or DACA or some other status or temporary permission to be here or agreement not to prosecute you. If you are going to try to adjust your status and get a green card, any crime could be something that could potentially be a negative factor. And getting your green card and adjusting your status to a permanent resident is a discretionary decision by immigration. So you want to avoid any convictions at all, if possible, because it's not going to help your application. And if you already have your green card and want to apply for citizenship, because this is a crime, you will have to disclose it on your application. This particular offense probably is not what we would call a crime involving moral turpitude. But if it gets into the felony level, it may not be what we call an aggravated felony for immigration purposes, but it might be considered a crime involving moral turpitude. Your application might be denied, or you may need to just wait at least 5 years after the offense or after any sort of sentence is done before applying. I would highly suggest talking to an immigration lawyer to determine the best plan of action.
Thanks, Karen. Lisa Ann.
So I'm going a little bit. I had a conversation with Rebecca yesterday about the slippery slope from the traffic infraction to an aggravated unlicensed operation. So can you kind of describe how a person could go from getting a traffic ticket and how that could end up with an aggravated unlicensed operation or a suspended or revoked license?
Sure, I can address that, just what I've seen in my experience. I provided a little bit of an example yesterday to Lisa Ann, and I can reiterate that today. A typical traffic infraction is, I'll assign some traffic infractions just for purposes of making it clear. You fail to signal when you're going to take a turn. An officer stops you and you're ticketed with a traffic infraction. On that ticket, it gives you a day to report to court, and it gives you a warning about what can happen to your license if you do not report to court on that day. You don't report to court on that day. Now on another court, and some time passes. Now on another occasion, you roll up to a stop sign and you fail to make a complete stop, and an officer happens to observe this. He pulls you over again. Now he can run your license and he can see that not only have you just failed to stop at a stop sign, but you failed to appear to court on a prior ticket, that failing to use your turn signal. Now he can see, because you failed to appear, that you have a suspension on your license for failing to appear. Now that's what escalates it from just a mere not stopping at a stop sign to a misdemeanor charge of driving without a license, and so on and so forth. I think I went even further to say, he tells you, he has a friend come to the scene, picks you up, and says, make sure you show up to court now, not as just on this failing to stop at a stop sign, but also on this new misdemeanor charge of driving without a license. Now you don't show up to court again. This time now, because there's an aggravated unlicensed operation charge attached, that would be subject to a warrant that could be issued by the court for when you fail to appear. And then you could be brought in front of the court in a custodial situation. So that's how we see it kind of start from just a run-of-the-mill traffic ticket to an escalating situation that has a misdemeanor attached, if that makes sense.
Yes, thank you.
All right, why don't we head to the next slide? So this is kind of something that Rebecca just said, and this is also, I wanted to, before we leave the AUO, the aggravated unlicensed operation, emphasize some of the seriousness of it. So I did a separate slide on what I consider the serious consequences, and as you can see, they're like bigger and bolder so that you pay more attention to them. This is my first attempt in doing slides for presentations, so that's why I went that way. An AUO can result in fines, but it can also result in you being put on probation, which means that you'd be supervised by the probation department for up to 3 years, or it can result in jail time. And that is not odd. Like, that happens not often, but it happens regularly enough that it's a potential consequence. So it's something you have to take seriously. And if you don't appear in court while the case is pending or initially, there can be a warrant, as Rebecca just said. And then at some point, a police officer can take you into custody. You can sit in jail up to 24 hours before you're arraigned. So it's really important that you appear and take care of it. And I did say bench warrant. It could be a bench warrant or an arrest warrant if it's the initial beginning. Bench warrant is after you've appeared if you failed to appear a second time. And the arrest warrant would be your initial failure to appear. Karen or Rebecca, I don't know if you have anything further on this. You kind of spoke about AUO as well. I'll just give you a chance to say if there's anything further. Karen?
Sure. Yes, thanks, Judge. I would just like to add that sometimes when I see clients who have what they think in their mind are just traffic tickets, and I say just being their perception of what they have, it could be something much more serious. And as Rebecca said, you may have one offense that snowballs into something much larger, and it can turn into something where you have to end up disclosing the details. Say if you're applying for citizenship, you have to list every time you've been arrested, the outcome of those arrests, if you've ever been in jail, for how long. And if you go for when you go for your interview with an immigration officer, they may have a lot of questions for you. You have to provide the police reports. You have to provide certificates of disposition for any time you've been arrested. And they can request much more information. They could request that you provide minutes from the court proceedings if they want to know more about the incident. So things can quickly spiral out of control, where a person thinks they only got a traffic ticket, and it turns out to be a much bigger problem for them in terms of adjusting their status.
Thanks, Karen. Yeah, and I'll reiterate that the more times you fail to appear and the more charges you get, the bigger mess you have to get out of. So the best thing to do is to appear each time you're given a traffic ticket so that you stay on top of it. Rebecca, anything further on AUOs? Nope. Lisanne?
I just want to, I'm looking for a definition of probation. People who are new to this country might not know what that means.
So what probation means, if you're sentenced to probation, there's a government department called the probation department. They're basically peace officers, or they have law enforcement powers, and they work for the county. And if you're on probation, that means that for a period of time, usually 2 or 3 years, sometimes 5 if it's a felony, you have to sign a contract with the court and probation as part of your sentence that says that you have to abide by all their rules. And those rules can include you need to report with your probation officer once a week. You can't go into certain establishments. You can't commit any illegal offenses. You need to live by a curfew. They're going to regulate whether you get when you get a job. You have to have a job. It's a lot of rules you have to live by. And if you don't follow those rules, they can then go back to the court and saying, hey, they're violating the rules of probation. And most of the time when that happens, you end up getting resentenced to jail time. So it's a very intense, strict supervision by a government agency for a period of time. How's that, Lisa Ann? Is that good?
Excellent. Thank you.
Rebecca, anything you want to add to probation? I just kind of came up with that on the cuff.
I don't think so.
Okay, so we covered it. Thank you. All right. Yep. All right, so now we're going to talk about impaired driving. And there's a big difference. I'm sure you all know the term DWI, or driving while intoxicated. There's a lower level of offense called impaired driving. And the impaired, we're going to talk about the intoxicated driving after this slide. Impaired driving is a traffic infraction, not a crime. So similar to our first slide. And it's the allegation or the charges that you were driving while impaired due to consuming alcohol. So when we were going over these originally, Lisa Ann asked me, how can you explain the difference between impaired and intoxicated? And I don't want to give you legal definitions because I don't think that's helpful. The best way I would describe it, and I'm anxious to see if Rebecca has a better way, is if you're impaired, it means that you've had some alcohol and that alcohol has affected your abilities. It doesn't have to affect your abilities a lot. It just has to affect your abilities. So if you've had a couple drinks or a drink even, and that an alcoholic drink, and then it affects the way you operate your vehicle, then you can be charged with impaired driving. Intoxicated means you've drunk to a level where you are drunk or intoxicated. And there's all sorts of legal language about, when you give a breath sample and what level you are. But this would be, you could get impaired driving from one drink. If you're charged with impaired driving, which it's not something we often see at the outset. It's not usually the charge. They usually do charge you with the intoxicated. It's not a crime again, so you're not entitled to that free lawyer. You'd have to hire your own. But there are significant money fines if you're convicted of impaired driving. And usually, if you're convicted, there'll be a period of time after the conviction that your license will be suspended, so you will not be able to drive. And usually, as part of the disposition, you're required to go to some treatment if you have an alcohol problem, or at least be assessed or screened to determine whether you have that alcohol problem. So it's got some serious consequences, even though it's a traffic infraction. So I'll turn it over to Rebecca first on this.
I was trying to think of a way, Your Honor, to explain it without going into like case law or a legal definition. I think most people probably, when they think, like you said, of intoxicated driving, they think about the DWI, and there's DWI per se, which is that attachment to what people are most familiar with, a 0.08. But there's other ways that we can prove intoxication. We can look for common symptoms that someone is impaired to an extent. And those are things that most people are familiar with: slurring your words, glassy, watery eyes, an odor of alcohol, not performing well on field sobriety tests. Intoxicated is a higher, I guess if you think about it in steps, would be a higher standard that you're more incapable, because of your level of alcohol that you've consumed, you're incapable of being able to employ the faculties necessary to operate a motor vehicle in a reasonable and prudent manner, whereas impaired driving would be less than that. I'm not sure, Judge Amoroso, if you have like a better way to describe it than less than. It's such an individualized determination, as it could have a different effect on a different person. I could consume alcohol and be at a 0.06, so not charged with DWI, but I could be presenting with, some slurring of my words to an extent where my faculties might be affecting my ability to operate that motor vehicle safely, where somebody else at a 0.06 might not exhibit those same, but alcohol has an effect on people. It's just different levels of how it interferes with your ability to operate a motor vehicle. I probably made that more confusing than need to be. It's just, I would say the simplest is considering it in an escalating, where it would fall in the steps of escalation. Did I more confuse that, Judge Amoroso?
No, I think you did good. It's hard because like Rebecca and I could very easily give you what the legal definitions that we live by are, and that's not going to help you understand it. But I think the important thing for you to know on this, those that are listening, is that most likely if you get pulled over and there's signs that you've consumed alcohol, your eyes are glassy or bloodshot, you're slurring your speech, they smell alcohol, you're just exhibiting common symptoms that you've had a few drinks. For the most part, I would say, Rebecca, you're going to get charged. Even if you refuse to give a breath sample and they don't have a number, you're going to get charged with a DWI. I don't know if I've seen a lot of initial charges at this impaired driving. It is something that later on in the case, sometimes there might be a plea bargain where they'll let you plead to this to resolve the case. So, okay, we're going to give you a break on this one. We're going to resolve this. We're going to let you plead to this traffic infraction rather than the crime. But I haven't seen a lot of initial impaired driving charges. I don't know if you have, Rebecca.
Not a lot, but that's likely because most of the cases that I see that way are starting out as investigations and might not actually get to a charging decision for that. In most cases where there's a serious physical injury or even a fatality, most investigations are going to request that the driver submit to a portable breath test. And that is sometimes where we can see the levels that might fall below what someone would typically associate with a DWI. Again, what Judge Amoroso said about most cases starting off as a driving while intoxicated and being reduced down to an impaired driving, those decisions are typically made based on equities unique to the defendant, or they also might be made, without going into too much detail, based on legal issues with the case, where there's certain weaknesses in what we can and cannot prove. And that might be taking into consideration that somebody might be showing less signs of intoxication, but because they've consumed alcohol and because of the reality of the effects that alcohol can have on one's ability to operate a motor vehicle in a safe manner, it gets reduced down to an impairment.
Thank you, Rebecca. Yeah, I think the important thing is that we're spending a lot of time trying to explain the difference between impaired and intoxicated. But obviously the overall message, which I'm sure that everybody in this presentation wants you to get, is that if you are drinking alcohol, you should not be driving, regardless of what level you think it affects you. You just should not be driving. In today's world, with the ability to easily call an Uber or to get someone to give you a ride, it's just something you shouldn't do. Before I go to Karen, I do have a question. In New York State, you are charged with both common law DWI, DWAI, and the BAC-based charge to cover anyone stopped and charged. Yes, usually there are different levels. When we get to DWI, and I'll handle this the next slide when we get to actual DWI. That's a question from Yvonne. So Karen, why don't you jump in on the impaired driving, the traffic infraction?
Actually, before we move on, I just wanted to mention one thing to tag along with what you were saying, Judge Amoroso, just as to like what our intention here is. Based on research that we see, it's not just that, oh, you're below a 0.08, you're just impaired, you're not intoxicated, you're not a danger on the road. That is actually very far from the truth. Research suggests that area of where you might fall in the BAC spectrum, sometimes when it's lower, you're actually more of a danger on the road because you believe that you're safe. You are acknowledging that you have been drinking, but you think that, oh, I've just had 2 drinks, I'm okay. That's ignoring the reality that those 2 drinks still, even if you're under a 0.08, still have an effect on your ability to operate that motor vehicle. So sometimes it's those drivers that we actually see as more responsible, not more responsible, but are causing collisions and accidents and things of that nature as well.
Thanks, Rebecca. Karen, why don't you jump in?
Sure. So with this offense, again, if someone wants to apply for their green card, that is a discretionary decision by the officer. When you apply to adjust your status and potentially get your green card, your fingerprints are checked. Basically your rap sheet is run. So this is something that the officer would very likely be aware of, even though we are calling it or referring to it as a traffic infraction. This could potentially be, a bump in the road for you getting your green card, particularly depending on your history. If there are other offenses and your criminal history, if this is solely the only time you've ever broken the law, you may still be able to get your green card. If you are applying to become a citizen, if this happened very recently, particularly the last 6 months or last year, even though it is a traffic infraction and not a misdemeanor, you still have to disclose it on your application because it is an offense. It's probably not considered what we call a crime involving moral turpitude. And immigration looks very closely at the last 5 years prior to when you filed your application to see if you have committed any of these crimes involving moral turpitude. This probably is not one of them, but you still may have to answer a lot of questions about it. It could still result in your application being denied. There is a catch-all provision where if you've committed any unlawful act, your application could be denied. And also, if you have anything else in your background that would show that you have a problem with alcohol, you might be found to be what they call a habitual drunkard. So that's something that people need to be aware of. That is a grounds for, it's an issue that immigration will look more closely into if you are what's called a habitual drunkard. And an offense like this may tend to result in that kind of finding.
Thanks, Karen. Lisanne, anything on this, or do you want to wait till we get to the DWI slide to kind of ask questions?
I just have a general question. If a person is hiring their own attorney because they're not, they don't have a right to a free attorney, how would they make sure that their immigration consequences were being looked at with whatever happens with this ticket or any ticket?
That would be for you, Karen.
Sure, I would ask the lawyer, tell me what the consequences are. Your lawyer should find out what your legal status is, and they should be telling you what the immigration consequences are. If you have some reason to doubt your attorney's advice, you should get a second opinion. I hope that answers the question, but your lawyer should tell you what the consequences are. Ask them to put it in writing if you don't understand. If you still don't understand what they're explaining to you, ask them to go over it again and again with you, what the potential consequences are, and ask them any questions that you have. That's why you're hiring them. That's why you're paying them money. They should answer your questions. If you're not satisfied with their advice, maybe you should hire another attorney.
Karen, I think there's a presumption that you got to bring that to your attorney's attention, right? I mean, even in court, when I have someone in front of me, I don't necessarily know whether they're undocumented or have any sort of immigration issues unless they tell me. And it's hard to make presumptions nowadays. You don't want to insult anyone by asking questions. So your lawyer might not ask you about your immigration status, especially on a traffic ticket. So it's kind of some duty on you to ask them. Is that correct? Am I making sense?
I would think so. I not practicing in criminal courts. I can't say what another attorney's duty would be, but I do believe that anyone who is giving legal advice to someone regarding the potential consequences of pleading guilty to anything, they should ask, the person, what is your legal status? What's your criminal history? I think that there is a requirement that a defendant be advised of their immigration consequences, which would necessarily mean that the lawyer's asking them, what is your status?
Thanks, Karen. I guess my thought is on that is I agree with you that there's some duty on the lawyer, but I would imagine, especially with traffic tickets, that's not a routine question they would ask at intake. So I just want to make sure if that's you and you're going to hire a private attorney, like, don't be embarrassed to tell them about any status issues, because they need to know that and they might not ask you. So I just wanted to make sure that that's communicated.
Right.
Fair, Karen?
Yeah, I agree. And the attorney should explain to you the attorney-client duty of confidentiality to help you feel more comfortable with talking about your status. And they should explain what that duty of confidentiality is and how any information you tell them is protected.
Thanks, Karen. Lisanne, we're ready for the next slide? Yes, let's go to the next slide. All right, this takes us to intoxicated driving, and we've kind of talked a lot about it in comparison to impaired driving, but DWI, or intoxicated driving, is a crime. It's either a misdemeanor or a felony. It could be raised to a felony, which is a more serious crime, as we talked about earlier, based on the fact that you have a record, you have more than one of them within a certain time period, or if you have a child in the car, it can be immediately raised to a felony. And it is for being intoxicated from alcohol or from drugs. That can be legal or illegal substances if they're, they make you intoxicated. This is a crime, a serious crime, so you will definitely be entitled to a free lawyer if you financially qualify, if you don't make enough money, or you can hire your own. And it's punishable by significant money fines. Obviously, we're talking even more here. It will result in a license suspension. And the important thing about this is most of the time, a lot of times, it will result in a license suspension right at the beginning. Your first appearance, your license could be taken away, depending on whether there's a blood alcohol test or a refusal to take that test. It usually results in requirement for you to go to treatment. And if we want to go to the next slide, Lisanne, it might be easier to just talk about the DWI ones altogether. And here's the significant things. It can, again, as with the AUOs, it can be punished by probation or significant jail time, especially if it's a felony. Your failure to appear in court can result in the issuance of a warrant, as with the AUOs. And if you are convicted of DWI, you will be required to pay for and drive with an ignition interlock device, which is a device that will be put in your vehicle for a period of time, at least 6 months. And during that period of time, anytime you drive, if you're like, once you have a valid license, you have to blow into it and it will not let you start the car if it detects alcohol. So a lot more consequences for DWI, a lot of consequences. It's a huge public safety issue. So we really want to make sure the people on the road are safe. Rebecca, I'll turn it over to you.
Not really much to add there, just maybe to address, again, how this is an escalating elements of the crime, and the one way that it becomes and goes from a misdemeanor to a felony is based on someone's criminal history. So if you are charged, not just charged, but also convicted of an 1192 offense, and within the next 10 years, you're charged again with a violation of driving while intoxicated, that elevates the crime from a misdemeanor to a felony. So the facts and everything can be the same, but because you have that previous conviction, now you're facing possible felony sentencing structure in regards to that. So you could have done the same thing, driven, rolled through a stop sign, got pulled over and charged with the regular misdemeanor DWI, but because of your history, now you'd be facing felony prosecution for that, which elevates the sentencing structure even more so. DWIs are very expensive, and they're intended to be expensive. There's significant fines associated with them. There's also jail time that can be associated with them in addition to fines. So somebody could be sentenced on a DWI, misdemeanor or felony, to a fine and also a period of incarceration. And we just see then the effects that can have on someone, and the day-to-day charges associated with the ignition interlock device. Those are typically part of our plea dispositions in these cases because the DMV requires these to be part of dispositions. So there's not a ton of flexibility with DWI sentences, just because they intend them to do what we all intend them to do, is to discourage people from driving while intoxicated.
And I'm going to add a little bit based on the question we had earlier in the chat about there are some different types of DWI charges depending on whether or not you give a breath sample. Sometimes they would say, did he blow? Did she blow or did she not blow? That means blowing into the testing device. You'll be asked most likely to do that. And I'm not telling you what to do when that happens. If you do refuse to do it, that can result in an additional charge and a license suspension. If you do it, they're going to have an accurate record of what your blood, the content of alcohol in your blood was. So some of the charges are based on that actual blood alcohol content, but you can also be charged with what's referred to as common law DWI, meaning we don't know what the blood alcohol content was, but we believe there's probable cause to believe the person was intoxicated, or you can be charged with both. And that's what often happens, is even if you do give a breath sample, you might get charged with both having the high breath sample and for the common law DWI. And then the other question, I'm looking back through my text messages because I believe Lisa Ann asked me for what those fees were. And it looks like it's in the hundreds of dollars for those ignition interlock device fees over a 6-month period. You're going to pay an initial fee of about $120, and then you got to pay every month $100 or so. So it's some money. So Karen, we'll turn it over to you.
Sure, thanks, Judge. For this offense, if someone wants to apply to adjust their status and potentially get a green card, again, any arrest that you have is going to be on the radar screen of the immigration officer. It could result in your application being denied, particularly if you have multiple offenses for DWI. I can think of one situation where someone's a refugee, they've had multiple DWI offenses, which landed them in immigration court. And if one of the incidents involved a child, that could be considered a crime involving a child, which you may not end up getting deported, but even if you don't, you might never be able to adjust your status. So if you have multiple DWIs, that's going to be a problem if you want to adjust your status. Could you eventually become a citizen? Say if you already have your green card, if you get one DWI offense, it probably would not result in you being found to lack the good moral character. But if it happened very recently, it may be too soon for you to become a citizen. An immigration officer may decide that you committed this unlawful act and they may deny your application, especially if you don't have any evidence to show that you have rehabilitated your character. Meaning, have you completed any treatment? Have you become more active in the community? And any positive factors like that. So you may end up needing to wait 5 years after the incident before applying to become a citizen. But if you have multiple DWI offenses, it may result in you being found a habitual drunkard, or you may just never become a citizen. You should seek the advice of an immigration attorney to find out, what your options are. But saying it's not a crime involving moral turpitude, that's not to say it's okay. It can certainly be found to be something else. Like I said, a crime involving a child. If it's something involving drugs and a drug offense, it could be a controlled substance offense. So there could be a lot more implications to what you may think is just a traffic stop.
Thanks, Karen. Lisanne.
Two comments. I understand that, or the information I think the Oneida County DWI office has put out is that a DWI can cost as much as $10,000 with fees and fines and attorneys and stuff that you have to pay to the DMV. I think for somebody who's not making a lot of money to begin with, or maybe the family makes a decent amount of money, that's a lot of money to pay to be to fight this thing, or to drive drunk. Better to call a cab or a Uber or a Lyft. Just a comment.
Yes, there is. I don't think that number is incorrect. It's significant financial penalties and fees and costs to getting a DWI charge. All right, so that is the end of the slides. I didn't do an ending slide. So I guess I'll just run through everybody one more time to see what else they might want to say. Rebecca, anything else you want to add?
No, but I can be available for questions if anyone has any.
Thanks, Rebecca. Karen?
Same, I'm available for questions. Thank you.
All right, Lisa, and I will stop my hosting duties. Though I did enjoy it, I could see me having my own talk show someday, maybe. As long as Lisanne's my sidekick, and I'll turn it back over to you, Lisanne.
We've got it. We've got this. Does anyone have any questions? I see we have 15 people on the call. Does anybody have any questions? You can unmute, you can put it in chat. Alicia, do you see any questions?
I do not see any questions as of right now. No.
Okay. So I think we're going to close with that. Thank you so much for coming and enjoying this discussion on these driving crimes, or not enjoying, but I hope it raises some awareness and we understand a little bit more about what we're getting into when we drink even just one drink of alcohol or take medication that might impair our driving. So this discussion was brought to you by the Office for New Americans Opportunity Center and the Center's Traffic Safety Program. We thank Judge Amoroso and Rebecca Kelleher and Karen Southwick for joining us. Karen is available for consultation at the center. She's Hiscock Legal Aid for immigration questions. You would contact Alicia and the ONA, who's the ONA project coordinator, to get an appointment with Karen. Thank you very much and have a great day.
Thank you,
Thank
Lisa.
you.
Thank